Welcome once again to Lehto's Law. Here's Steve Lehto.
Steve sent me a case involving social media and the police, and it's an interesting case out of Pennsylvania, reported by the Associated Press. Mark Scalfaro wrote this. Pennsylvania's Supreme Court ruled that the state police cannot hide from the public what its policy is on how it monitors social media. Advocates for civil liberties cheered the decision. The law enforcement agency had argued that fully disclosing its policy for using software to monitor online postings may compromise public safety. And the real question is exactly what were they doing that's caused all this concern? Because, if I've got a public-facing homepage, or I've got a social media account that's not limited to certain people, and anybody can look at it, I would assume the police can look at it too. But the question then is, are they doing anything else? Are they posing as different people? Things like that. So 4 Democratic justices supported the majority decision, which said the lower Commonwealth Court went beyond its authority in trying to give the state police another attempt to justify keeping details of the policy a secret. And so this order now appears to end a 6-year legal battle. And that's actually part of the story, is that there's a process whereby they can object to things or raise arguments. And the court is now saying, well, you guys could have probably handled this a little differently, but the way you did it didn't quite work out for you. State police spokesperson said the agency is reviewing the court decision, but of course reviewing that might not get you much further down the field because it's the Pennsylvania Supreme Court speaking to how the Pennsylvania police, state police, can act. So I'm not sure a higher appeal will get you very far. The lawyer with the ACLU of Pennsylvania said the ruling sort of puts law enforcement on the same playing field as all government agencies. They have a legal justification to keep something secret, then they have to put forth sufficient evidence to justify that. So that's the point. They said we've got this secret process. We can't let people know what it is. It's our secret sauce. And it turns out that Pennsylvania has laws and rules and regulations about what they have to do when it's a government agency with secret policies. So he argued that people need to know what police are doing in order to decide if it's appropriate. Ultimately, that relies on the voters understanding what law enforcement is doing so that then, through their elected representatives, they can rein them in when they're acting in a way that doesn't comport with what the public wants them to do, says the ACLU attorney. And I've mentioned this before. If the government's doing something that you don't think they should be, or vice versa, then you can complain through the political process. That is, either vote for or against the policies that you like and by the representatives and so on. Or, of course, you can file lawsuits and so on. But here he's saying, let's get these methods and practices out in the open so people are aware of them, and then they can make decisions with some education. Justifying what the majority opinion described as heavy or complete redactions on every page of a 9-page regulation. The head of the state police's Bureau of Criminal Investigations argued that greater transparency about the policy would make its investigations less effective. The State Office of Open Records held a private review of the redacted material and ruled that making the policy public would not be likely to harm investigations, calling the social media policy processes strictly internal and administrative in nature. Redacted sections address the use of open sources, what approval is required, and when to go undercover and use an online alias, and how to verify information. State police also had redacted entire sections on using social media for employment background investigations. So you go to apply for a job with the state police, and they check your social media accounts. You might expect them to do that, but is the fact that they do that something that should be kept top secret? And so I've got questions, but apparently the Supreme Court of Pennsylvania said, A panel of 3 Commonwealth Court judges reversed the office's open records ruling that would have disclosed this stuff without redactions, saying in May of 2018 that the state police investigations chief based his analysis about the risk of exposure on his own extensive experience. But that was the lower court ruling. The majority decision now said that court should not have given the state police a new opportunity to lay out the supposed public safety risks. The majority ruled that Pennsylvania's right to know law does not permit Commonwealth courts to order additional fact-finding, which had not been sought by the state police. If the state police had requested the opportunity for additional fact-finding, our disposition today may have been different, says the opinion from the majority. The open records law has a timely and efficient process that should be followed, noting that 6 years has already passed. So somebody put a request in to see this information 6 years ago. And a couple years ago, a court said, no, this stuff is not available and should not be available for good reason. And then that process wound its way up to the Supreme Court of Pennsylvania, and they said, no, this doesn't make any sense. So if and when appellate review is allowed to serve as a reset button based upon a court's ill-defined policy concerns, there is no limiting principle, and the judiciary's claims to neutrality and ordered decision-making vanish. And so what they're basically saying is that once this thing has been litigated and is working its way up on appeal, an appeals court can't say, well, you know something, we think there should be some more fact-finding here. The Court of Appeals is supposed to rule on what's in front of it. In a dissent, one justice said the lower court identified a question of fact that was unresolved, whether there was a connection between the text of the document and risks articulated in the agency's affidavit about public safety. She and another justice who joined her in the dissent are the high court's 2 Republicans. So apparently, let's see, we got 2 plus 4, we got 6. There's either 6 judges on that court or there's an independent. But it's always interesting to me when they actually designate and say this judge is a Democrat, this judge is a Republican. And it varies from state to state. In Michigan, courts are supposedly nonpartisan. So you do not run for a judgeship and say, vote for me, I'm a Democrat. Vote for me, I'm a Republican. Vote for me, I'm a Church of the Flying Spaghetti Monster-tarian. You don't do that. You just say, I'm running for and name the office. And that's how they work the judgeships. Now, it's well known that some judges are going to be on this side, some judges are going to be on that side. And based on some of the things that have happened in the news in the last, 20 years, for those of you who follow these things, when a Supreme Court justice, for instance, gets nominated to the U.S. Supreme Court, you can usually guess by who's doing the nomination and how big the fight is in the Senate as to which side they're going to come down on any particular issue. And so that stuff is known. But for those of you who are real skeptical, you should know that there have been justices appointed to the Supreme Court where everybody assumed, oh, this person's going to be over here. And sure enough, they show up over here and stay there for the rest of their career. And it's an interesting situation because Supreme Court nominations are for life. So a person can be on the court for quite some time. And of course, once they're on the court, they're usually there for quite some time. And so they can drift whichever way they want. And occasionally you'll get somebody who can be very conservative on certain issues, but liberal on other issues. And you get these kind of mixtures as well. So they do point out that it does appear that the 4 Democratic justices voted one way and the 2 Republicans voted another way. But that's how it worked out. However, keep in mind that there are apparently in Pennsylvania laws about what can be kept from the public and what cannot be kept from the public with respect to documents and so on. And so we all know about FOIA requests, for instance, and so on. So if you wanted to see the policy that the state police have got on something, you can file a request for that. And there's a process for your filing a request, and they're responding to the request. And there's this whole thing that goes on. And most people don't get that tied up in this kind of stuff because, we're not all sitting around requesting for the policies of the Pennsylvania State Police. But somebody who does this requests the information, and then they get something back that's been redacted, and then they object to that. There's a process for handling the objection and all of that. And so this wound its way around and eventually got, and yes, this is my hand motions, my sock puppet motions for something working its way through the court system of Pennsylvania. Very similar to something working its way through the court system of Michigan, or something working its way through the digestive tract of a flatworm, but another story altogether. So anyway, what basically happened here is the upshot is Pennsylvania has said through their high court that the state police cannot hide how it monitors social media, at least not based on what they had in front of them. And if they didn't have the right stuff in front of them, that wasn't their fault. That was someone else's fault. So there you go. Steve, not me, sent that to me from the Associated Press. Mark Scolforo wrote that. Questions, your comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Dude, bummer.